for that.
Okay, help me then understand your opinion in the Cassell case. This is about Governor Pritzker in your state, his orders, or within your jurisdiction, his stay-at-home order during the COVID-19 pandemic. He issued an order that allowed essential businesses and operations to operate at 50% capacity, but it applied only to secular institutions and services. He explicitly said religious activity was subject to a different rule. Religious activity, churches, synagogues, could only have 10 people in them. Everybody else, all other essential services, could have 50%, so hundreds of people go shopping, whatever. But religious activity, only 10 people or fewer for those folks. Different rule, explicitly different rule.
Today, we're diving into a fiery Senate Judiciary Committee hearing, where Senator Josh Hawley grilled Judge John Z. Lee, a judicial nominee from Illinois, about religious freedom and equal protection under the Constitution. This all stems from Judge Lee's decision during the COVID-19 pandemic to uphold a stay-at-home order in Illinois, which restricted religious gatherings more severely than other activities. Senator Hawley pressed hard.
You upheld that in the Cassell case, this differing standard that singled out religious people for disfavor, and you said that the Supreme Court of the United States has said that different rules apply during pandemics. The strange thing is I'm reading the case on which you relied, and it says nothing of the sort. You cite Jacobson versus Commonwealth of Massachusetts. That's a 1905 case. You say that the Jacobson court explained that the traditional tiers of constitutional scrutiny do not apply. That phrase doesn't appear anywhere in that opinion. Tiers of scrutiny weren't invented by the Supreme Court for another 40 years. So help me understand where you're coming from in this case. Why did you conclude that religious people could be singled out for disfavor?
Thank you, Senator Hawley, for that question. As I stated previously, when I decided the Cassell case, which was later affirmed by the Seventh Circuit, it was early on in the pandemic, and we did not have the benefit of the various other rulings by the Supreme Court that came down after my ruling on Cassell.
That held just the opposite.
That I guess I'm referring to Roman Catholic as well as Handon.
Right, in which the Supreme Court held that you could not single out religious people for disfavor. State of New York tried to do precisely the same thing. And the Supreme Court said, actually, plaintiffs have a strong likelihood of success on the merits. You said they have no likelihood of success on the merits. So just help me explain. The Supreme Court took a totally different view. Help me explain how you looked at the same Constitution and came to a totally different conclusion. Why is it okay to single out religious people for disfavor? I don't understand it.
What I looked at was whether or not the Governor Pritzker's order was neutral and generally applicable, to decide whether, at that time, secular activities were generally applicable. I looked at the type of activities as well as kind of the sort of risks, the varying degree of risks that were present in those instances. So, for example,
well, can I just stop you right there? I'm sorry, I've only got 1 minute left. I'm sorry, but you've raised, I think, a really important point, because the standard is, when it comes to First Amendment violations, is the law neutral and generally applicable? This regulation wasn't neutral and generally applicable. It had one set of rules for shops, businesses, and a completely different set of rules for churches, which is, of course, what the U.S. Supreme Court ruled. I don't understand how you can look at that and say it's neutral and generally applicable.
The order, as I recall, also closed, for example, movie houses and auditoriums, as well as schools. And so when I considered the activities at movie houses and schools compared to activities carried on at churches, I found those to be, at the time, using the time pre-Tandon test, to be generally comparable or comparable. I agree, and I found that But
the order said that religious houses of worship were essential. So it said that essential businesses could be open, essential services, but at 50%. Initially, it didn't include any carve-out for religious, any acknowledgement that religious services might be essential. He amended that, said, no, they are essential, but I'm going to cap them. So two completely different rules.
He pointed out that even the Supreme Court later disagreed with this kind of approach, ruling that the government couldn't single out religious gatherings for harsher treatment. If you're finding this analysis interesting, go ahead and click the subscribe button so you don't miss future videos on important hearings like this one. Thanks for watching, and I'll see you in the next one.